This is Jerome Corsi with a message for the readers and participants in 1776nation.com about the Supreme Court decision that was just rendered on the immigration law in Arizona, SB 1070. The Obama administration thinks that a great victory could be achieved by essentially pandering to Hispanic voters and declaring amnesty, if not officially, at least in effect. So by the executive action putting into place the DREAM Act for those who have been in the United States for some time or were born here and have achieved some educational or other contribution to the country, such as military participation. Now with the Supreme Court deciding in the 1070 case that in fact stopping illegal immigrants can also be a problem on the highway, a profiling issue. It wasn't ruled unconstitutional, but that issue is going to be reviewed again by the courts. And within hours, Janet Napolitano and the Department of Homeland Security, in a very retaliatory action, told Arizona that no longer could Arizona state and local law enforcement participate in the 286G program, which essentially empowers and trains state and local law enforcement officers to work enforcing hand in hand with the federal agents the federal immigration laws. Now the problem is that when someone's stopped in a car or a crime or whatever and the citizenship issue is at question, the state and local police have to be able to get onto some computer system to find out if this person is an illegal immigrant, if they're here legally or not. And what the 286G system achieved was to provide computer hookup to the Department of Homeland Security resources where these kind of determinations could be made quickly. Now what Janet Napolitano and ICE and Eric Holder are basically saying today and through the rest of this discussion is amounts to dereliction of duty. The President has determined unilaterally that unless an illegal immigrant has committed a crime more than just being here illegally, some type of felony, or is caught in the act of crossing the border illegally, or is a repeat border crossing offender, the person will not be deported. In fact, ICE won't even come and pick that person up. So if a state is trying to enforce a state immigration law, they get no backup from Department of Homeland Security or ICE, and there's no effective mechanism to get that person into a deportation setting. So the message is going to go out very quickly that essentially you can probably get a work permit if you are here in the United States for any length of time and get even a GED, equivalent high school degree, or if you're here illegally, as long as you don't commit a felony, then you're not going to be able to be deported. You won't be able to necessarily get a work permit, but you can figure your way out of that once, in fact, you're allowed to stay in the country. So this is, in effect, a decision by the Obama administration. They're not going to enforce, the Obama administration is not going to enforce the immigration laws with minimal exceptions. And the problem is some of the immigration laws are written with affirmative responsibilities for the federal government, demanding the federal government take action. Congress has been much tougher on these issues, especially as we've gone through now the Bush administration, George W. Bush, not strictly enforcing immigration laws, and the enforcement we've had, the deportations that Obama wants to take credit for, have largely occurred by the George W. Bush administration putting into effect these 286G programs, which I think we're on the verge of seeing canceled unilaterally. Now the ramifications of this, when you get into the politics of it, the Obama administration and the Democrats are throwing a little party for themselves, thinking they've got all the Hispanic voters. But before that party is celebrated too extensively, there's two factors I think the polls are showing. One is the Hispanics themselves care almost more about jobs. In other words, it's not just enough to be in the United States. If you can't find a job, then what's the point? So the availability of jobs is going to be an issue. And secondly, if we get somewhere between 15 and who knows how many million currently illegal aliens now going to have more legal status in the United States, they're going to compete for social welfare benefits, jobs, educational opportunities, able to apply to colleges, and in a environment, an economy where jobs are scarce, where educational opportunities are competitive, where communities do not have the resources to provide extensive educational training in foreign languages, in Spanish, unless it's to the detriment of the English-speaking students in the school. For every voter among the Hispanics gained, there's going to be a multiple of voters lost among those who care about the enforcement of our immigration laws. I think, in fact, there's never been a more important moment for the Tea Party to get engaged and to say, in fact, our concern is not that we don't want open immigration. We want it legally open, but controlled. This system is going to invite criminals to come into the country again until they commit crimes here. It's going to put increased burdens on communities for social resources that they don't have available, with now communities in the United States beginning to declare or contemplate declaring bankruptcy. And I think in terms of the voting calculation, the Tea Party needs to express the determination to have rule of law and immigration policies that are in compliance with the rule of law, and a federal government that doesn't think it's an imperial federal government. The most disturbing point about the Supreme Court case was the Supreme Court itself seems to have forgotten that we the people are sovereign. And then when the Constitution was written, when the federal government was created under the Constitution, the states were the sovereigns, and the federal government was created with limited powers. Now if the Supreme Court says the federal immigration laws are supreme, and the states can't even pass laws that agree with the federal law, this is ridiculous. In fact, the federal government, as originally contemplated by our founding fathers, the idea would have such limited powers that the states would be encouraged to experiment. And it would not be wrong for one state to have an immigration policy that would be different from another state. Those who favored the immigration policy one way or the other would simply migrate to the state of their choice. So we've come so far from the limited government concept of our founders. I think the immigration issue has become more than ever a Tea Party issue, both on the question of national sovereignty and on the question of an increasingly burgeoning federal debt that this Supreme Court decision will almost certainly grow larger simply by placing more immigrants into the social service system, the educational system, etc., which will put a burden on public taxpayer funds to be allocated to those social purposes. So we're going to follow this issue very closely. 1776 Nation is at the center of these concerns. I appreciate and thank you for your interest. This is Jerome Corsi with 1776nation.com. Thank you.